Obviously, I'm Dave Clapp. That's probably not obvious to all of you, but I've been around Raisin for a while as your past president in 2020. One of the fun things that I had the opportunity to do in 2020 was we purchased this site, and then I was involved and chaired the committee that actually renovated this building. And I'm excited to be here because this is actually our first presentation that I'm involved with in this new space. So that's pretty exciting. I also am a member of the committee that is putting this program on, the Realtor Attorney Joint Committee, and at the state level serve on the Forms Committee, both the FAR Bar and the Standard Forms Committee. For my real job, I'm the managing broker at Remax Alliance Group, apart from all the other volunteer stuff that I do. So enough of the intros, let's get into the panel. We ready to go, guys and gals? I don't want to leave out the gals. So our first question, and we've got a series of about 9 questions that we're going to weigh in on throughout the panel. And we will allow for some questions as we go through each of these. As the panelists share, it will be allocated to one panelist to address it. The others may jump in and will answer questions specific to the question that's at hand. So what is post-occupancy and when do you see it utilized? Pam?
Thank you. Can everybody hear me? Okay, perfect. So post-occupancy is when a seller of a property would like to remain in the property after the buyer has purchased the home or residence or property. So we're not seeing it, this has always been something once in a while it would come up where for various reasons, sometimes it's only a couple of days while they get their movers to come in to coordinate a move. When we went through the buying frenzy in the last couple of years, it became much more prevalent because the sellers were, for lack of better description, and more in control, and they needed more time to either find a place or whatever. And so we saw it really expand, kind of has settled down, and we'll get into that a little bit later. But it's basically when a seller wants to remain in their property after the property has closed and title conveyed.
Any pros or cons to it?
Well, there's a lot. I mean, it's certainly great when a buyer and seller can work together to make something work for all parties. Sometime a buyer, particularly in this area, may not be coming to town and, they want to enjoy it for season. So they may want to have somebody in the property, whether that be with a lease, without a lease, at a cost or not. But there's caution in that, because once the property closes, the seller now is a tenant. The seller is not the owner of the property. Things have to be very well defined as to whose responsibilities there are. And you can imagine where challenges come up, where a buyer closes on the property, the seller is in the property, the refrigerator dies the next day. I don't know whether we'll get into a little bit more detail on that in some of the other questions, but it is something to be very cautious of and make sure that all parties know the risk versus the benefit.
So this is a pretty easy thing that agents can just do on their own. They don't need an attorney to do this, do they?
Oh, I really highly recommend getting an attorney involved. That was one of the first things that when I counsel buyers or sellers in the process, and that may come up. A seller says, I want to stay in my property. I don't want to close for 6 months. That's what the time when you talk about what the risks are, what the advantages are, and always say it is best to consult an attorney, particularly on the, they can say, I want to do this, but I will never, I'm not an attorney. I won't give advice. And that is a word that we try to avoid, particularly as a transaction broker. I know some of you may be single agents. The other part is that they are the experts on writing leases. We are given an 11 or whatever our page contract here is, because we fill in the blanks. We are not to interpret law or to practice law, because then we could get in trouble. Aside from a bad reputation with your clients if you misguide them.
Good. Excellent. We're going to get into more of a deep dive into this. Pam was just setting the stage for when we would use a post-occupancy and the fact that they've become far more popular. So we're going to move on to our second question, and that is, how should post-occupancy be incorporated into the contract? So Mallory, help us understand that.
Absolutely. So the first thing you should not do, and I see this all the time, unfortunately, and we have a slide up here, is having language in the additional terms that says buyer agrees to allow the seller to stay in the property for up to 45 days after closing. There is a rider that you should all become very familiar with. It's rider U, the post-closing occupancy by seller. That should be used any and all times when a seller is remaining in the property post-closing. This has the perfect verbiage. You do have a contingency that's built into this. So while you might just be writing in the additional terms, seller shall stay up to 45 days, there's so many X, Y, and Z's. It's not detailed. So first and most important is you have that contingency built into this rider. It gives ample time for buyer and seller to come to terms on a mutually agreed upon lease or post-closing occupancy agreement. And if for some reason they don't come to terms within that time period, either one of them has the right to actually terminate by providing written notice. So that's very important. I've had a horror story happen with that, with a $250,000 deposit. And if this rider was not utilized, buyer's deposit would have been at risk. Another thing that this rider details is who is going to pay for that post-closing occupancy agreement. So it could typically be the seller, buyer, or equally split by both parties. Also details on how long the seller will remain, how much are they going to pay. That's usually a very important term. And all of that is also just stating that if for some reason there's any ongoing maintenance, the seller does still have that obligation. But in regards to repairs in paragraph 12, seller is not going to be obligated to continue to make repairs post-closing. We'll get into what exactly a post-closing occupancy agreement should state as we progress into this program. But the importance is to always use this rider, never be writing in the additional terms. These are drafted for use, so don't ignore them.
So is this rider the actual post-occupancy agreement?
No, this is not. This is a precursor to the post-occupancy agreement.
So this just adds language to the contract,
Correct.
but it's not the actual post-occupancy. And who writes them?
An attorney does.
And we'll talk a little bit more about that. So moving on to our third question. What is the importance of a post-closing occupancy agreement being in place? Ben, we're going to throw that one to you.
Sure.
Our liaison.
So the reason you want a post-closing occupancy agreement is because it creates a lease. It creates that landlord-tenant relationship that will provide the landlord, the tenant, the buyer, and the seller, whatever their position is at the time. It's going to provide the benefits of Chapter 83, which is the Landlord-Tenant Act, rather than not having the rights afforded under the statute. In addition to all the other items that you can lay out within the post-occupancy agreement. As was just stated, that addendum, that rider is not an agreement. It says that the post-occupancy agreement shall provide that. All that is an agreement to agree, and that's not an enforceable lease. So just filling out the blanks in that rider and throwing it in as an addendum, even though everybody signs, that is not an enforceable post-occupancy agreement. The contingency is the reason you use that addendum, and the contingency is enforceable. You can terminate if you don't enter into a post-occupancy agreement. But other than just being an agreement to agree to enter into a post-occupancy agreement, that is not a valid lease. So you need that extra actual post-occupancy agreement. Within there, you can lay out what's the rent, who's buying insurance, and depending on whether it's the seller, whoever the owner of the building is at the time, they're going to have to buy the property insurance, while the now tenant is going to have to cover their contents. So without a lease, without something specifying who's going to take on that obligation, you don't get it. Risk of loss, who's going to, if the house burns down through no fault of either party, is there insurance there? Who's that, how is there going to be recovery on that? So we'll talk more about the terms that should be included, but that's why you want it in writing, because if you don't have something in writing, you're not going to get it for your client. So I think that pretty much covers it.
Let me pursue some some agents feel like when we do a post-occupancy agreement, we don't want it to be a lease that falls under the Landlord-Tenant Act. We just want to let the seller hold over for a couple days. Do you see any advantages to having this post-occupancy agreement being considered a lease that falls under the Landlord-Tenant Act?
Well, for the seller, absolutely, because it allows you can put in the lease full rights and remedies available under the Landlord Tenant Act that will allow you to get that tenant out, to get the buyer out, or sorry, to get
Yeah.
your now tenant out
Right.
expeditiously. You know, again, terms you can include, you can recover your attorney's fees and costs, you can recover rent, you know, even security deposit. If you want to say, hey, in exchange for this agreement, I want you to pay a security deposit, which is going to be separate from the escrow and earnest money, or I want you to pay for the 3 months you're going to have post occupancy upfront, so you know they're not going to default on the rent. You're going to get paid for it as the seller, or as the buyer now, the owner of the property. Sorry, I'm getting the
Yeah,
roles
it's all right.
confused. Sorry, but that's the idea. You want to be able to activate Chapter 83 and have all your duties and obligations in writing, so it's binding. Because if you don't have it, you're not going to get it just as somebody who's allowed to stay for 45 days.
Yeah. And I want to reinforce that point because as a realtor for years and years ago, we used to try to structure these so that they weren't considered a part of the Landlord-Tenant Act. And there was thinking among the real estate community that we don't want it to fall under the Landlord-Tenant Act. But as Ben said, when you try to evict that seller who's holding over, if you don't have the Landlord-Tenant Act on your side, the process is a lot more expensive and a lot longer. So we do want it under the Landlord-Tenant Act. Thanks, Ben. Any questions on this so far? We're doing so well. Everyone's so quiet. That scares me. Yes. I'm going to hold that because we're going to come to that in just a second. So, but it is a great question. So let's go on then to question 4. What should the post-occupancy agreement include and who pays for it? How's that?
I'll start with your question first. So in regard to who is drafting that, when you're using the rider, even if it says at seller's expense, typically in Sarasota, Manatee County, I'm usually representing a buyer. I also would say that typically there is no seller's counsel on the other side. All transactions are not the same, but what I do is ask the seller, or by way of the listing agent, are you going to engage counsel to draft this occupancy agreement, or are you okay with me drafting it? As a reminder, I represent the buyer. Obviously, I'm drafting it as a neutral party. In that instance, I'm drafting it as a closing agent. I'm not drafting a wicked agreement by way of the seller. But I'd say probably 90% of the time when I'm the closing agent, even if it says seller's expense, I'm usually drafting it, unless the seller has specifically engaged counsel to have that drafted on their behalf. And then if they
So
want
the
to.
question
I'm
was,
gonna
even
review
if
it from
they're
a
a
buyer, though.
retired attorney and they want to draft it, would you say, Mallory, yes, you're still going to do it?
They can do that if they're a retired attorney and they want to. I am 100% going to want to redline it, or at least look at it, because at the end of the day, the buyer who I'm typically representing is going to be that landlord in that situation. So I want to make sure that those rights and obligations are appropriately assigned. All right. So what should the post-occupancy agreement include? So there's going to be a litany of items that the post-closing occupancy agreement should include. In regards to the most important things, typically time frame. So how long is this going to last? How much is the seller going to be paying? Also important to note that in Rider U, it says that monthly rent is due in advance. I get this question all the time throughout transactions. If somebody is staying 3 months, well, we'll pay monthly. Obviously that can be discussed in the post-closing occupancy agreement, but it does state in the rider that it shall be paid in advance. So just of note, there are 2 little words that sometimes have become litigious throughout the process. In regards to insurance requirements, who is going to hold insurance? Is it just going to be a renter's policy, or what type of policy are we going to have there and require? utilities, landscaping, HOA dues or condo dues or pool service, who is going to be paying for all of these things? The post-closing occupancy agreement is going to detail all of that. Security deposit is typically a very big item as well. Sometimes we have security deposits, sometimes we don't. There's also two different methods that we can kind of use with a security deposit too. We can either have the security deposit cut from the seller's proceeds and physically give the buyer a check at closing. So the buyer is going to be responsible for handling all of that. Some parties prefer that the closing agent actually escrows that money at closing so that there is still some attorney involvement there. There is no wrong or right answer. It's totally up to the buyer and seller. Any restrictions? So a lot of people, especially in the post-COVID era, are working from home. So I always like to have something in there stating what can the seller do in the property? Are they going to be conducting a business? Are they a seamstress? Are they just going to use it as primary or principal use? In regards to buyer having access, as a reminder, they are now the homeowner. So are they allowed any access? Is it 24-hour notice, 48-hour notice? A big one too is always maintenance and repairs. So the rider states, and most times the lease will say as well, that the seller's maintenance obligation is still intact, so meaning that the seller has to provide the same property in similar or same condition when they vacate, which leads to another item of, is there a separate walkthrough? Or are you doing a walkthrough the day of closing and then a walkthrough on the day of seller's vacation? Something that I've done a couple of times is set a repair limit, that if there's $1,000 repair limit and something breaks in the property, seller agrees to cover everything at 1,000 or less. Buyer may agree if it's 1,000 and a penny, the buyer will pay for the penny. So we've done that as well. We can kind of put whatever we want and whatever is important to buyer and seller in a post-closing occupancy agreement, and they definitely differ from transaction to transaction. Yes? Yes, you would. So that's something that the buyer and seller have to discuss amongst themselves if there are no leases to be allowed. Yes. Well, I mean, I would never hold back money if there's no lease in place, and no attorney will
So
do that.
Mallory, before you answer, we have Zoom and they can't hear your question. So let me repeat the question. And the question is in regard to some HOAs or condominiums do not allow leases. And when we're doing this post-occupancy agreement, it is a lease. And how does that deal with HOAs and condos where they say you can't lease it for less than a year, or you have to own it for a year before you lease it? How does that play into when we're doing a post occupancy and allowing the seller to hold over under a lease term? So I'll
Pam
let you go
really
back.
wants to answer this question, so I'm going to let her answer, but I just want to answer, well, week versus 3 months. All of the liabilities are there, whether it's for a day or 3 months. If somebody falls through or dies or there's repairs, doesn't matter how long the time frame is, but Pam is super excited.
I'm
Go
not
for
super
it.
excited, but she did just close on one of the things that I was thinking in my brain. And that is, I've done a number of post occupancies, in this market area over the last 15 years. And to Mallory's point, even if it's one day, here's the thing, it's not going to be a problem until it's a problem. And if I, as a realtor, haven't educated the consumer, whoever I'm representing, on what the risks are, who they're going to come back to. So I believe that most attorneys are going to have a basic template for the minimum things. Maybe this is, if it's just a week, that those items that she listed have to be there, but it may not go into as in depth if they're staying for a long time and they're going to run a business. So I just would like to say, I hope that everybody just saw in that 3 minutes of what she brought on, why adding seller may remain in the property for 45 days after closing just doesn't cut it, and how important that you rider is. And every transaction is unique. So, I mean, we've had where somebody's just staying overnight, right? Because the mover didn't get there or whatever. So I think each transaction has to be individually looked at. And in that case, it may be a simple hold harmless if it's an overnight for the mover. But make no mistake about it, all of those elements, whether it's a week, 3 weeks, and I've seen, in fact, I was involved in one where the holdover was 6 months. It was not that unusual in this crazy market. Now it started to slow back again. But to me, it didn't matter if it's not just an overnight thing, and we still would have attorneys involved in that. But if it's any further than that, there should be some post-occupancy agreement.
Yeah, and I would echo that. And I would like to say also, I think a seller holding over is different than them introducing a whole new third party coming in. And the HOA and association will still recognize that it's the same owner of the property who's been there. I'm not sure that they're going to give you a problem, but every HOA is different. And as long as we're talking about the time for holdovers, another consideration is that if the buyer is financing, they are signing an affidavit in their mortgage documents that they will occupy within 90 days. So anything longer than that creates a problem with their mortgage. It's 60. So yeah, so you've got to be aware of that. Mallory, I want to go back and pursue a little bit more of this seller's maintenance. Right here talks about the obligation of the seller's maintenance under paragraph 11 continues after closing until possession's delivered. However, seller's repair, replacement, treatment remedy obligations shall not extend beyond closing. So a seller, if the AC breaks down and needs to be replaced, that says it's not on the seller. Do you normally draft something? You had mentioned something about minimum amounts. Do you normally draft something different than that?
So I usually, in my form template that I'm using, I have some sort of repair limit in mind. Because if it is a big ticket item, the buyer usually doesn't feel like they're responsible for it. If it's an AC or some big ticket item, because they're not utilizing the property right now, they weren't using it. This does state that the seller still has their maintenance obligation as well, which in paragraph 11 states that, the seller has to provide the property to the buyer on closing date in the same or similar condition it was on the date of the offer. So going through that way, it just really depends on the post-closing occupancy agreement and the parties, how they are. Also on the other point in regards to if it's 3 or 4 days, we also can draft a license agreement as opposed to a lease, where you have licensees, and the seller is actually acting as a licensee and you don't have landlord tenant. There you can use unlawful detainer instead of that. So I've had to do that a couple of times as well because it doesn't provide those landlord tenant rights for 3 or 4 days. It's a little bit less strict.
Yeah. So again, we want to emphasize the importance of having an attorney involved in this discussion for how long it's going to be and what the appropriate document would be. Get counsel on that rather than making that decision on your own. Moving on to question 5, we're going to come to Pam. What should realtors be explaining to their clients, and actually it should say customers, about post-closing occupancy?
How's that now? Ah, okay. So I'm assuming those in Zoom land didn't hear some of that. But I'll just be briefly repeat it. So it's educating the customer or the client, depending on your relationship, what their options are, because options, if they understand, if they do a lease back with a seller, or if they just do an extended closing. So we were talking about extended closing, which is another option. So they may say, you know, I don't want to own the property. I don't want to be a tenant, but I will let them extend the closing for the 90 days. Then I have the conversation there as to what the risk is there. You know, has the seller at that point asked for enough of a deposit? Again, I'm not making a recommendation, but if somebody's staying in the property doing a 3, 4, 5 month close, a lot can happen in that time. So explaining to them what the difference is between an extended close, what the risks are there. And then, and I do use the word risk, you know, here's the risk of keeping a seller in a property, and understanding what the tenant landlord relationship is, because that's basically what it is. You do become the landlord. And if something does break, now remember, the buyer will have had their inspection done. But if the air conditioner is 7 or 8 years old and performing perfectly fine, it still could die the next day after closing. And boy, we have seen this so many times where something happens. And then who do they call? They're going to call us. No matter what, they're going to call the realtor. And, you know, the AC, you know, died today. I'm not going to be taking care of it. Now, remember, it's still not our responsibility, but we want to keep those good relationships with our buyers and sellers down the road. So we want to help them problem solve if we can, or most of us do. So that's what I explain most, is what the risks are and what the benefits are. And then the consumer needs to make the decision what their tolerance is. You know, sometimes we know our clients, and there is, you know, if you have, and I go by disc profiles and things like that in my brain, but if you know you have somebody that is going to be super, super stressed over having somebody in a property, you know, they just need to understand what the risks are.
Good. I would just also say that some brokerages have developed some standard forms, and you can certainly, if your brokerage has hired an attorney or has in-house counsel and they have standard forms, for example, one of the reasons that they might want to do that is the rider U provides an opportunity for the buyer and seller to cancel if they're not able to come to terms. Well, I know some brokerages have desired to get that out and attach a post-occupancy agreement that the brokerage uses. And so make sure you're checking with your brokerage on the forms and documents that they use. Okay, moving on. Question 6. Pam, as a follow-up, with post-closing occupancy, when does a walkthrough occur?
I always recommend that the walkthrough be the day of the closing, which means the seller theoretically is not going to be out of the property, correct? Because they're going to have a holdover, they're going to stay in the property. So one might think, why would I do a walkthrough? And I highly recommend that a walkthrough is done, because the buyer then has their eyes on the property that day. Most of the time it's going to be with a realtor. I would attend, making sure that appliances haven't been changed out, which I've seen, by the way. You know, oh, you're going to get the refrigerator that was in the garage, you know, the old rusty one, and I'm taking my Thermidor. So things like that. So you basically get your eyes, you make sure that, you know, there aren't any holes in the walls, just a good understanding of the property before, so that when you do a walkthrough, when the seller exits, you have an idea of what the property was like. I've had people take pictures and video. Again, you know, depends on the parties, but I've had a buyer go through a walkthrough, the first walkthrough where the seller's going to stay, and they did a video. Obviously, you need permission to do that because you're videoing somebody else's furniture and other things. So.
Okay, anyone else want to weigh in on that? You agree? Okay.
I would say too, you can also add, you know, if the buyer is moving their furniture in, or the seller is moving it out, that can all be laid out in the post-occupancy agreement as to who's reiterate, even if it was in the original contract, reiterate, seller is taking this or this is buyers and it stays, that can all just be reiterated and laid out clearly in the post-occupancy agreement. So there are no questions when it comes to that turnover from the seller to the buyer.
Yeah, and there may be repairs that haven't been done. Typically on a walkthrough, when you close, the repairs have to be done. So what?
Sorry. It's his habit. He shuts it off. That is, that's a very valid point. What was we talking about?
The repairs. not
Oh,
having been
repairs.
done
So
you do
when
the
I do
first
that
walkthrough.
first walkthrough, I always recommend that the buyer, if I'm representing the buyer, that has proof that the repairs were done and that is completed and verified prior to the closing. Don't let it go past that.
Just stressing the importance of 2 walkthroughs, pre-closing and then pre-vacation. I have had an experience, and it is an experience, it's still going on, so I guess we could use the term journey, with an escrow holdback for a post-closing occupancy. $75,000 was held back because it was a high dollar property. The first walkthrough, there were no issues whatsoever. The realtors involved were very detail oriented. They actually had buyer and seller sign off that there were no issues. And then when they did the secondary walkthrough, the pool was the slightest bit lower than normal. So now we are going through a pool company to ensure that there's no leak. And parties, while they're very unhappy at the situation, they're both very, very happy that they have a post-closing occupancy agreement, and that they had such good realtors on their side, both of them, because if this was not so detail oriented, we didn't have the post-closing occupancy agreement, and there was no security deposit, who knows what the liabilities and rights and responsibilities of both parties would be. So that's just a real life practical application of why it's so important.
Yeah, and I will tell you that we've experienced walkthrough situations where the first walkthrough is done and there's a area rug over a hardwood floor, beds on top of it. When they go out and the seller's moved out, there's all scratches on that hardwood floor underneath that rug, and they weren't seen before. And so it becomes an issue. So you definitely need to do both of those walkthroughs. Smooth question. Yes. Okay. Right. So the question is for our Zoom members, what happens when you do the first walkthrough and there's a couch there? And then when the seller's vacated and the couch is gone, you find a section of the drywall is missing or some major defect that is uncovered. How do you deal with it? Panelist, who wants to take that?
Well, I think part of the answer is what you said. It's a defect, so it goes into did they disclose it? But so the first part of it, I think, goes into what you said, a defect. So if the seller didn't disclose it, there's that avenue. But in the post occupancy agreement, you could even say, the first walkthrough, doesn't waive, any damages or anything found in the second walkthrough. In a term that says after the second walkthrough, if there's repairs of X amount of dollars, then it'll be seller's responsibility and all that. It's a negotiated agreement. You can plan ahead and think of all these contingencies that can happen and provide for it. Because if you don't have a post occupancy agreement, if there's not that landlord tenant relationship, you're going to be stuck with basically what amounts to, in the eyes of the law, as a squatter in your house.
And what about security deposit? I mean, if there's security deposit, can that be used to handle such a problem?
So the Florida statute 8349 that deals with security deposits lays out exactly what it can and can't be used for. But that doesn't mean you can't put in the post occupancy agreement what you want it to be used for. So if it's silent, normally with a security deposit, the tenant will move out. The landlord has a certain amount of time to inspect, send a letter and demand, hey, pay me my, here's a list of repairs. I'm going to deduct it from your security deposit. And there's a whole process there, again, that you won't get unless you fall under the purview of the Landlord Tenant Act. But in the post occupancy agreement, you can specifically provide that, hey, you're paying $2,000 in a security deposit. This is going to apply to rent you haven't paid me. This is going to apply to any other damages that we find upon walkout, and then you're responsible for $1,000 over that. So again, all these contingencies can be considered and provided for.
Yeah, and I just want to emphasize what Ben just said. The post occupancy agreement can provide for some of those things that may not otherwise be provided for under the Landlord Tenant Act. So that's part of how that is crafted and how that is worded. So you need to pay attention to that. Question 7. What does post-closing occupancy mean for a buyer?
Well, I think it's clear by now, it means that they're going to be the landlord. The buyer is going to be a landlord, and that doesn't happen automatically. You're not automatically a landlord because you now bought a property that somebody is living in. You only a landlord. It's a pretty much a specialized term. That means there's a landlord-tenant relationship. So if you have a post-occupancy agreement, you are now a landlord. The seller is now the tenant. And so you have, again, like we've been talking about, all the rights and obligations under the agreement, but also the landlord-tenant statute. If you come to an attorney and says, hey, I have this contract that has just the addendum, or just has, like we saw the example where it said, seller has 45 days to occupy the property, that doesn't create a landlord-tenant relationship. Now, there are ways to get the buyer out, but you're not going to get your buyer is not going to be able to recover unpaid rent, because that doesn't say whether there's going to be rent or paid. There's no landlord-tenant relationship established. Under the unlawful detainer statute, which is how you get squatters or transient occupants out of your home, you're not recovering your attorney's fees and costs. So your buyer is looking at being out of their, in a worst case scenario, with somebody in their house, not paying rent, potentially causing damage if they're upset or whatever. We've seen it all, but they're not going to be able to recover any unpaid rent. They're not gonna be able to recover their attorney's fees, and they're gonna, it'll be a month before they see their home and be able to actually live in it.
So that just brought my thinking to again, you could make me go crazy. Right. So if the buyer is expecting to take occupancy on December 1st and the previous seller, now the tenant, decides I'm not leaving, there could also be, not everybody has 2 houses or places to stay, or they may need rent. So that's another whole factor that stick in the mud potentially.
So let me throw out this question. How do we ensure that the seller tenant vacates if it's a 30-day occupancy? How do we ensure they vacate at the end of 30 days? What can we do?
I would probably have the realtors follow up, because not everybody likes hearing from an attorney. So I would probably have the realtor follow up and say, hey, just a reminder, 5 days, this day you have to be out. And another thing too, that's just came to mind, you can specify in your post-occupancy agreement a time they have to be out. So do you want them out at noon? Do you want them out by 6 p.m.? Because otherwise, conceivably, they could have till 11:59 p.m. on the date of the end of the post-occupancy. So if your buyers or if your customers want to get in, the buyer wants to get in at a certain time on the last day, if they have it backed up to when they're wanting to take occupancy, maybe they need that seller out at noon and not at 11:59 p.m. on the 1st of February, whatever it is.
Can we build anything into the post-occupancy agreement that adds additional incentive to that seller to vacate on time? Mallory, you're shaking your head.
I put in liquidated damages clause that if they don't move out at 5 p.m. on that agreed upon date, they have to immediately provide $5,000 to the buyer. That is super incentivizing to a seller to get out of the property. So that's something that I have done. I don't know if Ben has others.
again, the Landlord Tenant Act, I can't remember the exact statute, but it has automatically a holdover provision. And you can back it up in your post occupancy agreement, but if you have a landlord tenant relationship, you fall under chapter 83, you can collect double rent for any holdover tenant. So if the rent was $1,000 a month, now they owe you $2,000 for every month that they hold over, and that can be prorated for however long that goes on. From a litigation standpoint, like I said, it could take a month to get this person out. If they hire an attorney and really muck up the situation, it could be 2 or 3 months before you get them out. If there is a lease that establishes the rental value, they have to pay that amount into the court registry to even litigate the case. And then they also would have to, where was I going? They have to pay the money into the registry to even litigate it. But as the case goes on, they're gonna have to continue to pay that rent. So if it was a 3-month post occupancy and then you had to litigate for another 3 months, the tenant is gonna have to pay 6 months of rent. So again, that's something you're not going to get out of a non-landlord tenant relationship.
Pam?
And a good reason, again, to have the walkthrough, if the tenant is supposed to vacate on a certain day by a certain time, I would try to do the walkthrough the day before, because if nothing has been moved out, the bedding not packed, the towel still on the wall, it could be a sign, and hopefully you'd have some time to, I've had a situation where you get to the property and it's like the seller hasn't left, there's still a lot of stuff. And then we just got some help and got it packed up and them out of there. That wasn't a post occupancy, but it could happen that way. So maybe doing the walkthrough, trying to schedule it the day before, would give you a heads up if anything might go a little wonky.
Yeah, I know one of the things that we do oftentimes is we build in a per day charge. So $250, $300, $500 per day for every day held over, and that money can be deducted out of the security deposit. So you don't have to fight real long or hard to get that, because if it's $250 a day, depending on how much security deposit you have, and they get out a week late, you've got that covered. Question. You've had a closing already, correct? Seller got proceeds, yes. Answer.
So again, you have to agree to have all those terms. If I was a seller, I would not agree to it.
So that's where I think you negotiate your security deposit and how large of a security deposit you want, depending on how much risk you think there is. Yes, question. Bank account. So Mallory did talk about who does the security deposit, escrow or paid to the buyer. So go ahead, field that
So
question.
There's really 2 options that I'm aware of that you can do. If I'm holding funds post-closing for a security deposit, the closing agent is going to be the escrow agent who is holding that. They're going to have some sort of responsibility. They're going to sign the escrow agreement as well, because they are holding funds post-closing. There's going to be very clear mechanism for releasing when and how and who tells all of that to happen. So typically, if there is some sort of security deposit, it's usually held by the closing agent. But I have had amicable situations where we actually cut a $5,000 check from seller proceeds, give that check to the buyer, made out to the seller at closing, so that they can handle it themselves. And then, the attorney's involvement is not there in regards to the landlord tenant dispute. But some parties want to do it that way, and sometimes I'm fine with them doing that themselves between a landlord tenant relationship. So it just depends.
So I want to make sure you all caught that, what Mallory said. If there's an escrow, there's a separate escrow agreement. So now we not only have a post-occupancy agreement, but we have an escrow agreement that gives the escrow agent direction on how they can release these funds. Is there a charge for that?
For me, yes. So there are very few attorneys, in my opinion, who are going to hold funds and take on all that excess liability for no fee. It's a super small fee, but I'm sure every closing agent is a bit different onto how they charge a fee or why they charge a fee. Obviously, some instances, if it's a last minute thing where you need this post-closing occupancy, fees can be waived. But typically, because it does take several back and forth between buyer, seller, and escrow agent of drafting this document, because at the end of the day, it is the legally binding document, there is some sort of fee associated with that.
Other questions? All right, then let's move on to conversely, how often do you see pre-closing occupancy? We're going to shift from the area of post and let the seller occupy to pre-closing where the buyer gets in and occupies. Pam?
So this one I see less frequently than I do post. So we would have a situation where the buyer wants to occupy before closing. And so it's almost like it would become a lease purchase, sort of, not with all that language. I'll let you all get into that. But that really comes with a little bit more risk in my mind. But remember, my mind is mine. The buyer or the seller may disagree with that, but I'm always fearful of a buyer getting in the property early and they just decide, I don't like it here. Or this door is squeaking and it wasn't squeaking a day, whatever. I mean, I'm trying to show you from minimal to something very large. It's not, I wouldn't necessarily encourage that. Let's put it that way. But again, it's always, what does a buyer or seller want? What's their tolerance level? So I don't see pre-closing often. I'm trying to think if I could even think of an example where I've had one in the last few years, quite honestly. Usually we can work around that some other way. You have one? You want to speak?
Go ahead, share it, Mallory.
The most often that I see pre-closing is typically when a simultaneous transaction is occurring. So if the buyer has sold their house and they want the sale and the purchase to occur on the same day, and then unfortunately the buyer's lender says, oh no, we don't have the clear to close now, they're homeless because their sale is still going to go on if their sale of buyer's property rider wasn't used. And again, in the past couple of years, we weren't really using any of those protection addendums for the buyers. So that's typically when I see it. I agree with Pam that it's not very common, but that is how I see it most often, is when there's a simultaneous purchase and sale and the sale still occurs and the buyer has nowhere to go.
We also see it when a lot of times we have people coming from out of state and they've sold their property out of state and they're buying here and the property's already vacant. And they ask, can we move in early before closing because the property is already vacant? The reason it doesn't happen so frequently is because properties are oftentimes occupied. The seller isn't getting out until closing. So you're not going to do pre-occupancy, but when it's vacant, that's when it opens the door for the question, hey, can we do pre-occupancy? We have a online caller who's asking a question. What if the buyer wants to bring possessions to the house, but not actually move in and occupy the house living in it?
So that's a very timely question. I'll answer from a standpoint of Realtor, and then the attorney can comment on that. And that we do see much more frequently, where, I've got a delivery of furniture coming in. And remember, each transaction being different. If there's not a lender involved, but once a lender's involved, now we got that 3-day rule. It used to be so easy to just do back-to-back closings. We'd even do 3 in a day, really. I mean, it was just nothing. Now it's very complex, difficult to do that because of some of the new lending laws. So very often we'll get that call. And that again is really up to the seller. Generally, I recommend, if you want to do that, and I'm sure Mallory or Ben will talk about like a hold harmless. I typically would never recommend that the buyer have access to the property without being accompanied, like by the Realtor. Many times it's like, well, you can put things in the garage, but we don't want you moving in. And I've had several times where it's okay, yep, we can put, yes, you can bring the piano or whatever the case may be. And then you find that they've got 2 trucks of other stuff. Oh, well, we were just going to add, this, that, the other thing, and they're basically half moving in. So that's why I always recommend that the realtor be there. And sometimes you have to be again, it's always up to the buyer or the seller. But at that case, I'd call the seller and I would just say, they want to move in, some of their groceries, their baby food, whatever. And then it's up to the seller to say yes or no. Most of the time, you're able to work it out if we as realtors stay level-headed and not put our emotion in it. Generally speaking, I think most of the time we can work it out, but that is when I see most prevalently having access to a property pre-closing is if they want to put some items in there. Maybe one of you can speak to the
Yeah.
liability
Let's
or
talk to the
not of that.
liability side of that.
If I'm representing the seller, I'm definitely wanting a hold harmless indemnification or at least a hold harmless from the buyer that says you can put X, Y, and Z in my garage, but you're not going to hold me responsible if it's damaged. You're doing this basically at your own risk. I have no responsibility to insure it, maintain it, protect it, put it all on the buyer. If you want to do it, you do it at your own risk. And so that's the only thing I can think of.
Agreed. Okay. Yes. Another question from the Zoom world. So that's going to lead us into our next question, because it's going to talk about some of those rights the buyer waives when they get into that. So I'm going to move us right into question 9. How should pre-closing occupancy be utilized in a real estate transaction? And specifically, we're going to get into some of the nuances of that, what rights are waived and so forth. And that's right in line with that question. So Mallory, we're going to throw that ball to you.
Okay, so I will answer that question in a little bit. I promise I'll answer it. I'm just going to start where we should start about the pre-closing occupancy rider. That is rider T. So we have post and we also have pre. They are very similar. Does create the contingency, does discuss how and when the possession will occur. The buyer, when they move into the property, if it's prior to closing, and this is also explicitly stated in the contract, they're waiving their maintenance, the seller's maintenance requirement and any repairs or replacements. So the buyer is accepting that property in that condition, that as is condition. Obviously, if there were repairs negotiated during the inspection period and the repair addendum, the seller still has that responsibility. But for those that had been negotiated already, the buyer is waiving all other claims in regards to the maintenance requirement for the seller and repairs or replacements. So that is a huge reason why we probably don't see pre-closing too often, because buyers may not want to be waiving that. Also, in regards to this pre-closing occupancy, a lot of time this is happening during the contract to close procedure. So we aren't really utilizing this rider because a lot of people aren't writing an offer with the pre-closing occupancy in mind. So a lot of times this isn't necessarily used. Pam, maybe you can talk about that in realtor perspective, but I don't see this rider used very often because most of the time when we are having pre-closing, it's a day before closing or an hour before closing that we're negotiating that. And we do still draft a pre-closing occupancy agreement. And this rider still allows for that. Even if this wasn't used, if I'm handling a transaction and there's going to be pre-closing occupancy, there is going to be some sort of occupancy agreement drafted. It'll state very similar things to what the post-closing occupancy agreement will. Important difference though is if for some reason the contemplated contract closing date doesn't occur, what happens? How quickly does the buyer need to get out? What kind of rights and responsibilities do each parties have? When I'm drafting these, I usually have between 24 and 48 hours for the buyer to vacate the premises. And if they don't, we can add some sort of per diem, or it depends on what was drafted, whether there's a landlord-tenant relationship there. But it's very important to have some sort of occupancy agreement drafted for pre-closing occupancy because the risk is still there. The parties are just flip-flopped.
And I think in some ways, the seller is more reluctant with a pre-occupancy. One, they don't get their funds. And in many instances, they're using those funds potentially for another purchase. The other thing is if there were to be a pre-closing, the seller will want assurance that the buyer is qualified to close on the property in the time. Why are they closing and it's subject to them closing on another property? Do they have proof of funds? What's the deposit? So there's a lot of questions there. And generally speaking, when I've been approached to pre-closing occupy, once it's explained to the seller doesn't want any part of it, except in a case of what you were saying is something's happened, where you close on a Friday, and if you have a loan and you're sitting there at 6 o'clock at night and the bank didn't send the wire, that could mean next Monday. And if that Monday's a holiday, and I know I'm bringing up these things, they have happened. In the first time it happens to you, for any of the realtors that may be listening that are newer, boy, I'll tell you, it is not a good feeling when you have a buyer that you're representing and they can't go enter the property that they're planning on moving in that night. And you have a seller that says, forget it until I have my money. Now, I think there's something in the law that it closes. Maybe you could speak to that, because do you know what I'm talking about? Like, just because the funds. Yeah. I just opened a can that perhaps is a little off topic, but I think maybe that would be good.
It's off topic, but we'll let Mallory answer it if she wants.
So the question is, and we get this a lot, the seller says, well, I'll give the keys when I get my money. That is not what the contract says at all. I always in jest ask the seller to please point to me in the contract where it says that. The only thing for closing to occur is the funds have to be collected. Collected is a defined term in the contract. So the funds have to be good cleared funds in the escrow agent's account. All closing documents obviously have to be signed and delivered. And then we have to have been in receipt and sent the funds. So if it is a Friday afternoon and closing occurred at 3:30, and we can prove that we sent out receipt of those funds to the seller, they do have to hand over those keys. It's not a quid pro quo of keys funds. We have international sellers where they might be getting a wire to their bank account in Canada, and that might take 4 to 5 business days, or maybe it's going somewhere else. Credit unions take usually at least a day. So the requirement for keys for money is a no-no, but I get asked it at least once a month. So good question.
And I can't resist. I have to jump in on this one too. I sit on the committee at the state level that writes the FAR bar contract. This version of the contract, the October 21 version, we made some very distinctive changes in the contract to deal with this issue because we heard it a number of times. For the first time in this contract, you have a definition of closing. Closing is when all of the required funds are in the closing agent's account, not the seller's account, and the closing documents are with the closing agent. That is now defined as closing. In paragraph 6A, it says at closing, the seller will deliver keys and access devices. Those two go hand in hand, and we wrote it that way to deal with this issue where the seller doesn't have their money. They won't have their money oftentimes, but closing still took place. And by the contract, the definition of closing is there, the keys must be delivered. So that was an intentional change that was made in this version of the contract to deal with that. Now, a wonderful change. You like that change? Yeah. But we want to go back to our question. Is there anything else that pre-closing occupancy to be utilized in a real estate transaction? How should it be? Anything else we want to talk about there? There's one other thing that I think needs to be brought up is prorations. Are they handled differently when you preoccupy?
No. Closing date. So when we prorate, it's based off the closing date.
Okay, the contract stipulates that on pre-occupancy, the prorations take place at the date of pre-occupancy, not at the date of closing. And that is in paragraph 6A. So that is, we talk about some of the things that are different that buyers give up, the right of maintenance and that kind of stuff, as well as the prorations are different. Pam?
I thought of one thing, and it applies to T as well as to U, addendum U, but I think it's more prevalent in U. And that question is, I've used this addendum as, and it says in there, the contract is contingent upon the buyer or selling within 10 days, or if left blank, delivering to each other a mutually agreed upon written lease, pre-closing agreement or similar agreement. I've had situations, and I just would like the attorneys to speak to this, where the buyer's closing agent will say, oh, we'll have something at closing. So technically, this says that within 10 days after the effective date, or unless otherwise specified, that there will be a lease in agreement in place. So I don't know whether either of you have had, maybe it would never come up. Again, there's never an issue if the buyer and seller are agreeable, but I would hate to get to 2 days before closing and not have the contract, I mean, not have the, the lease provided. Have you ever had that situation?
That was my briefly touched on the horror story earlier. It went to litigation. Parties, buyer and seller, had the rider. It was attached. They needed to agree to the mutually agreed upon post-closing occupancy agreement within 10 days of closing. They did not. So the buyer terminated. The seller disagreed that the buyer was able to terminate. And the settlement was $249,099.99, and the seller got a penny. So the buyer got, I would say, basically all of their escrow deposit back because that rider was used. If that rider was not used, there probably would have been way less of a settlement agreement there because that contingency was there and it wasn't agreed upon. They were still negotiating.
Excellent. Excellent. Good example. Any other questions? Yes, we have a Zoom question. So what happens when the seller doesn't have their funds in their account and they refuse to hand over the keys? How do you handle it? Mallory, you want to tackle that? Or Ben? Anybody who's done closings? If the seller refuses to hand over the keys because they don't have their money, but you have a closing that has taken place.
Yeah, Mallory does a infinite amount more closings than I do. I get the litigation on the back end, so that would be a pretty open and shut litigation case. But but I can let Mallory speak to the transaction part.
And the prevailing party gets attorney's fees too, right?
Yeah, under the FAR bar, the prevailing
Yeah,
party
they do.
we'll get their fees.
The reason I want to take it first is because I'm going to answer that from a realtor perspective, because we always hope that we don't have to get to the attorney level on that. So if that happened, the first thing I would do would be to appeal, just make an appeal and say, the money is not, the seller would prefer not to release the keys until the money is there. The contract does state otherwise, so that's where you would just go to an attorney and you can point that out. But I think sometimes just having the dialogue, would you have a problem with waiting, and most of the time would be, no, I can wait till tomorrow, or whatever. So in some instances, we as realtors can kind of diffuse things. We can't change what the contract is. And if the buyer says, I want the keys, the contract says that. Not saying don't share with the contract. And you can even say that the contract says that technically we close, that they can have the keys, but would you mind waiting until the funds are there tomorrow? And probably a lot of times the sellers would be agreeable to that,
Piggybacking off of what Pam said is setting expectations. Typically the sellers that want their funds when keys are exchanged, they'll let me know probably day one of the contract. So I can tell parties, whether it's buyer, seller, listing agent, selling agent, that we need to be ahead of this. If it's a cash transaction, I'm encouraging my buyer to wire the funds the day before, sign all their documents the day before if they're a cash buyer, so that we are closing first thing in the morning. So I am bridging the gap of when the seller does get those funds. So setting expectations for that is probably the most important thing. Fortunately, I have had situations where the seller does refuse to give the keys, and then typically after a phone conversation with them and reading through the 2 sentences in the contract, they usually hand them over. I haven't had a situation where the seller disagrees with me based off of what they've already signed. But I think setting expectations and just getting parties ahead of time of, okay, the seller really wants their funds. So Mr. Buyer, this is what we have to do to ensure that we have the smoothest transaction for both buyer and seller.
So don't schedule your closing for 4 o'clock in the afternoon because the wiring desk is going to be down and you're not going to wire those funds. But note, the closing agent can always give a paper check to somebody who's insistent, right? You still write paper checks? So paper is still available for that seller who says, you're not getting the keys till I get my funds. The alternative is we'll give you a paper check. Well, no, I want them wired. Well, the wiring desk is closed. It can't be done till tomorrow.
And you have to wait 10 days for it to clear, right?
Right. With a check, they're going to have to. Yeah.
Another really important part of that is we have to remember, again, I'm looking at things from my practice every day as far as a realtor, that this area, we have so many people from different states, and the rules and contracts are very different from states. So I do encourage, particularly if you feel you have a buyer or a seller that is a little more analytical, get them a copy of our contract up front. Just send them, give them a blank contract. You're going to be a hero. You'll have some people that aren't even going to read it until you sit there with them. But if they seem like somebody that's going to be analytical or question, I'm giving you a copy of, the Florida contract so you can have a better understanding and try to get those questions answered so that it doesn't come up as a problem.
Okay. Are there any other questions? We're coming up to the end of our time. And
So
Yeah,
what if
they're not in
what
their
if the
account.
lender's funds haven't arrived?
you don't have a closing.
The answer to that was then we're not closed.
The concept of a dry closing we used to talk about doesn't work under this version of the contract. There is no dry closing. You either have a closing or you don't. You either have the money there and the documents there or you don't. There is no dry closing. Another question do we have? So what are the issues between doing an extended longer close and a post occupancy?
I'll start from the realtor perspective. In fact, I have one right now that will close the end of next month, and it's about a 5.5 month delayed closing. The buyer did not want to become a landlord, just didn't want that. So they agreed while this person's home was being built, to extend that. So, some of the things that have come up is one, the buyer can kind of disengage somewhat from the property. Then they want to know, have the repairs been done? Has anything gone on? Like we had a hurricane, so it's a little bit more service on your end to keep holding the buyer's hand, which is not a negative. It's our job, but to ensure them that the property is still being cared for. And in this particular instance, there was just a small roof or a few roof tiles that came off, and the seller was very fastidious and everything. In fact, they let us know before I even had a chance to call. So again, I think the buyer and the seller, by the way that the seller cared for the property and it showed, I think the buyer had confidence that the way the property was maintained and the pride that it would be there. But it has been a long process, and it's kind of, it seems like it has been so long ago. The buyer is now getting super excited again, and the seller is immensely grateful because they have not had to go into temporary housing. But the longer that is, things in life change, right? So even though there's a binding contract and they are obligated to close, who knows if 2, 3, 4 months in, something happens in that buyer's life that they don't want to close. And that's why it's probably important in that situation that the seller has a very healthy deposit if the buyer is willing to do that, so that potentially if that happened, there would be some recourse. I think that's between that and anything that comes up maintenance wise and having that, that obligation, making sure that's clear in the contract, which it is as to whose responsibility. But I always fear that something could happen and the deal may not happen. I think that's my biggest worry.
Yeah, every transaction is unique and every buyer and seller is different. So I think if you, like Pam was saying earlier, just express to your buyer, here's the risks of not, a long close versus a post occupancy. And you'll have some people that say, I don't even want to be a landlord. They're terrified of the term. They don't even want to be associated with a landlord. They just don't want to deal with it. Then they don't have that appetite. And in a long close, I would make sure your contract does incorporate contingencies that could happen with repairs and deposits. And, this is a negotiated agreement, the contract is, so you can add in cutoff times for certain repairs, or whether or not, there can be a termination and who pays for what. So if you're going to do a long close, just make sure your contract, either in that paragraph 20 or in a separate addendum that is drafted, accounts for those extra contingencies that the FAR bar contract doesn't account for with a long close.
And then just to touch base on what they were saying, with your question of financed or cash, if you are having an extremely long financed closing, you have to ensure that your loan approval deadline is also matching that extreme length. Also probably want to fill in as many blanks as you can about interest rates. If interest rates are really low at that point, you probably want to make sure that you're having that the buyer is going to be committed to that exact rate, at least at that time, or market conditions. But that's probably my only other addition, was just to state that make sure all of the deadlines are matching up. You don't have a 30-day loan approval with a 120-day close. The poor buyer is never going to obtain loan approval in 30 days. It's just, yeah.
Lock in the rate. I'm going to allow our panelists to take any liberties that you would like to make any kind of closing statements, thoughts, ideas on post-occupancy, any message that you have for the audience that you want to end with. So Ben, you got the mic.
I guess the only thing I thought of as we were talking, and a reason you want a post-occupancy agreement in place is because once there is a closing and the contract closes, all the terms in that contract go away. It's what we call in the law, it merges into the deed. So unless the provision, and you'll see this throughout the FAR bar contract, unless it specifically states that this provision shall survive the closing, all those terms and conditions, whether it's an addendum, whether it's repair obligations, those go away on the date of closing. So how do you provide for that? You have a separate agreement that survives closing, and that's another importance of the post-occupancy agreement, and not just writing in paragraph 20 or just leaving the, filling in the addendum, seller gets 45 days or whatever, because that provision is going to be extinguished at closing and it's not going to be enforceable at all because of what's called the doctrine of merger.
I just think the biggest tip from today is to please use the riders, especially rider U, because that is used more frequently, and to not write any leaseback terminology in the additional terms. I think that's the biggest takeaway. And reach out to an attorney that you know and trust and work with, because they're there to help. That's what we do in the community. We want realtors to be protected, and we don't want you guys to be committing UPL.
I absolutely love what Ben just said, and that I think puts it really very much into perspective. Once it's closed, all of those terms are extinguished. I think that I would use that and explain that and be able to say that to, that's my takeaway, is using that language when I'm now dealing with customers, because that's the reality. And so therefore you're on your own if you don't have any other type of agreement. I think that the other thing is, it always comes back to understanding and knowing the contract, and our contract does change, periodically. Some of us do, I've been very blessed to do 60, 70 transactions a year over the past, I know you become more familiar, but the realtors that will do less transactions per year, just as good as anybody else, but maybe you're not as familiar with that. So just kind of keeping yourself informed, especially whenever you see a contract class. There are many attorneys that do, extra training on that. And I know I'm speaking here because I'm so involved in RAISM and have always participated in education, but I just can't tell you that has kept me out of trouble for a lot of years by just not understanding something because I hadn't experienced it. So I would say that, and coming from New England and New Hampshire, working with attorneys versus title companies, I mean, it was like, oh my God, you're going to use an attorney, it's going to be terrible. It has been such a blessing here because both the title companies and attorneys, they seem to work a little bit more harmoniously. But the reality is that I know that I can call any of the attorneys here or others and get information. They want to help us, want to educate us because they don't want to be handling a conflict at the closing table.
Thank you. We are at the end of our time, but I want to thank our panelists and once again, go through each of their names because some of you on Zoom did not hear it. Pam Sharon, who is a broker associate with Compass. Ben Sorrell, who is a attorney associate with Schutz and Bowen, and Mallory Bauer, who is an attorney partner with Berlin Patton Ebling. So thank you all. And our sponsor, some of the folks did not hear you. If you want to come up and announce, give us your name and your company, and also we're going to do a drawing.
Thank you, everyone. Again, I'm Kyle Cutchin with Homebridge Financial. Make sure you did get your card in here. Did everyone get their card in here for the drawing? Okay, like I said, free dozen eggs. Okay, let's see. We'll have the panel pick out a card. Yeah. Oh, we got one. Hold on. And just to give me a quick plug here as well, too, extended rate locks. If you have a borrower getting into that situation, we do extended rate locks for up to a year, 12 months with a free float down. So that's very important, especially if you're going to delay closing for that long. Okay, so the first winner. Oh, Shirley. Where is Shirley? Shirley, she won. Shirley. Okay. You have got a Publix $25 gift certificate for a half dozen eggs. I'm sorry. Yes. And one more? Yeah, we got one more. Or I'm sorry, that was to Amazon. Was that Amazon? Amazon. This is the Publix ones. That's Publix. I got two Publix. Okay. The second winner? Okay, it's Amazon. Okay. John. All right. John, you got a free Publix. Okay. All right. Thank you, everyone. And make sure you eat some of this stuff so I don't have to take it back to the office, please. Thank you.
Thanks, Kyle. Hey, thank you for coming and participating with us. I hope you learned something. More importantly, I hope you go use it to put together some real estate transactions. Go out and make it a great day. Thank you.